Yo, G-I-B-B-O, that's the moniker, man's on a mission. Got a weird walk like a pigeon on commission through the council estate. He's moving with pace, got a crew of old geezers right on his case. Switching up outfits, quick like a flick. 1 minute he's a Bobby, next to geezer with a stick. He's dodging and weaving through the market store mess. He's got a big grin and a cheeky little vest. It's Gibbo, mate, I'm on my Benny Hill now. Chasing everybody through the whole damn town. With a ding-ding sample, yeah, you know the drill. The whole manor's running from Gibbo Hill. He's on your tail, can't get away. He'll chase you till the end of the day. See him skanking through the high street with a purpose, yeah, tripping over curbs, but he just doesn't care. He's got a whole posse, a flash mob of fools breaking all the rules. He's a milkman, a butcher, a postie on a spree. He's a man of 100 faces, can't you see? 1 minute he's a flirting with the ladies in the park, next he's running from a vicar in the dark. It's Gibbo, mate, I'm on my Benny Hill now. Chasing everybody through the whole damn town. With a ding-ding sample, yeah, you know the drill. The whole manor's running from Gibbo Hill. He's on your tail, can't get away. He'll chase you till the end of the day. Now watch him pull a trick, alright, proper stunt. He'll swap his suitcase for a rubber duck punt. He'll slip on a banana, then get up to salute. Still a traffic cone and wear it as a boot. He's hiding in a phone booth, but his bum's sticking out. He's got a wart pistol making everyone shout. He's painting a fake door on a brick, will you see? Then he'll run right through it, faster than a flame. It's Gibbo, mate, I'm on my Benny Hill now. Chasing everybody through the whole damn town. With a ding-ding sample, yeah, you know the drill. The whole manor's running from Gibbo Hill. He's on your tail, can't get away. He'll chase you till the end of the day. Yeah, Gibbo Hill, the dawn of the chase.
Hello. 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 It's Lucy. Yeah, welcome. Yeah, welcome. Karen, as always. Me, well, you know. Yeah, hit the like, share, subscribe. Get this out there. Lucy again. Jinx coming in with the like, share, and subscribe. Okay. So today's live is about. Oh, okay. Shaboot sent a super chat. Thank you for that. Yeah, I can park that. There you go. Oh, let me go. I told you stop telling me what to do. Okay. Oh, give me a second. Jesus, wet. Is it any better? Is that any better? I don't know. Okay, let me find that again. Share screen. Take that off. Go. Okay. So Letecia Stauch has been granted a retrial, meaning that she's going to get a retrial. I've got the document. I've just pulled it up. We're going to go over that and find out why. Why has she been given a retrial? She's probably the most disgusting person that I've ever come across in true crime. She's absolutely vulgar. Now, I did ask Lee, as you know, she's my legal expert, to come on and lawyer it for us, as I read it, explain it, but unfortunately she's working. So, there you go. We are going to jump straight into it. Again, thank you, Shaboogs, for the super chat. Thank you for not being a boss. I didn't see that. Letecia, yeah, Letecia. Aurora says, I'm so mad. I watched every minute of Letecia's trial and she's exactly where she should be. I can't believe Gannon's family will have to go through this again. Yeah. I wonder if, what was her name? Oh, I can't think of her name. Zab girl, that was it. If she'll be covering it after the controversy that she went through. Is that everything? Everybody there? Sleuthy saying hello to Rescue. T-shirt. Yeah. Hi, everyone, with a dog emoji. Let's get to it then. Okay. So, here's a document. Now let me get it up. Same Aurora, and now we're going to have to listen to annoying voice and lies again. Well, no, they won't go over the same things again. I wouldn't imagine it would be like a case for the defence to go over anything. So here we have a little box at the top. That's just explaining what the document is. Summary, April 2nd, 2026, case number, People versus Stauch. A division of Court of Appeals considers whether an erroneously denied challenge for cause is waived, or invited by virtue of the fact that the defendant does not use peremptory challenge to remove a basis juror to correct the trial court's error. The majority finds neither waiver nor invited error in this context and apply People versus Abu Nantanbu, and then case number concludes that error warrants reversal for structural error because a biased juror deliberated. The dissent concludes that the defendant waived the right to claim error on appeal by exhausting all of her prompted challenges without excusing the biased juror. Colorado Court of Appeals, case number. Court of Appeals, case number. El Paso County District Court, case number. Honorable George R. Werner is the judge. People of the State of Colorado, plaintiff appellate versus Letecia Stauch, defendant and appellate. Judgment reversed and case remanded with directions. Option by Judge Paul Gomez J. Concurs Bernard. Okay, I'll skip all that. And then they're the people I'm guessing that are involved. Okay. Defendant Letecia Stauch appeals the judgment of conviction entered after a jury found her guilty of the first-degree murder after deliberation, first-degree murder of a child under 12 by one in a position of trust, tampering with a deceased body, tampering with physical evidence, and multiple crime violent sentence enhancers. Because we conclude that the trial court committed structural error by denying Stauch's challenge for cause to a biased juror who deliberated, we reverse the convictions and remand for new trial. One, background. The prosecutor presented evidence at trial that Stauch brutally murdered her 11-year-old stepson, GS, we all know who that is. Put him in the chat with some hearts if you want. In Colorado, put his body in a suitcase and left it underneath a bridge in Florida. Stauch has pleaded not guilty by reason of insanity, arguing that she suffered from dissio, whatever, identity disorder. But the jury rejected that defense and found her guilty as charged. The trial court sentenced Stauch to life imprisonment without a possibility of parole, plus 2 consecutive sentences for tampering convictions. On appeal, Stauch claims that the court committed structural error when it denied her challenge for cause to a biased prospective juror who then deliberated. She also asserts the court erred by denying her request to suppress evidence obtained pursuant to an overboard warrant and by admitting certain testimony by her ex-husband, GS's father. We agree that the court committed structural error when it denied Stauch challenge for cause and a biased juror deliberated. As a result, her convictions must be reversed because it's likely to arise on remand. We also consider and reject Stauch's Fourth Amendment challenge to search warrant. However, we do not reach remaining evidentiary issue. Challenge for cause, applicable law, section provides that a trial court shall sustain a challenge for cause on one or more of the following grounds. So, first one, relationship within the third degree by blood, adoption, or marriage to the defendant, or to an attorney, to any attorney of record or attorney engaged in trial of the case. And then we have the existence of a state of mind in the juror evincing enmity or bias towards the defendant or the state, unless the court is satisfied from the examination of the juror or from other evidence that he will render an impartial verdict according to the law and the evidence submitted to the jury at the trial. So basically, one of the jurors must have been very biased, running around telling people that they had the bias, and that's why it's come to this, because they didn't give the state for cause. Okay. Jurors who fall within one of these categories are considered biased as a matter of law, impliedly biased under subsection 1B and actually biased under subsection 1J, unless they can be rehabilitated upon a challenge for cause. The trial court is required to excuse them because, and then except as described in subsection 1J, they cannot be rehabilitated. And then it's got the case that we went over, mentioned earlier. Okay, in People versus Macrander, the Supreme Court held that when an elected district attorney is the attorney of record, section 1610, 103, 1B, includes prospective jurors are related not only to the elected district attorney, but also to any deputy district attorney in that office at the time jury selection occurs. And then we got to look at, okay. Overruled on the grounds by People versus Novotny, 2014, Colorado 18. That is, the statute directs automatic removal of a juror related within the third degree, any deputy district attorney in where was I? Attorney office includes prospective jurors who are related or not only elected to not only elected district attorney, but also any deputy district attorney in that office at the time jury selection occurs. And then we've got that number. Then we've got that. That is the statute directs automatic removal of a juror related within the third degree, any deputy district attorney in the elected district attorneys of record office, regardless of whether the deputy district attorney appeared or participated in the case. See ID Act 242. This preserves the appearance of, not the reality of, fairness in a crime prosecution and public trust and confidence in criminal justice system. Okay, let's have a quick look at the chat, see what you ugly mugs are up to. Mark's here. Welcome, Mark. Thank you for coming. Okay, so she's a monster. He was stabbed 18 times, had blunt force trauma to the head and cracked his skull and shot, had defense wounds on his arms, hands, and he was only 11. Yeah, she's a vulgar piece of shit, but the fact of the matter remains, I don't agree with the decision, but there are laws for a reason and people have rights for that reason. Someone says, hi, Ruckus. I didn't see Ruckus. Maybe I've got to scroll up. Oh, what's this then? Yeah. What is this then? This is the first man I've ever known to have a house delivered. Good to see you, Ruckus. Rescue there, giving the girls some honour. Jinx linking you to the website if you guys want to check out that website. Okay, so if you're just tuning in, please go back to the beginning to where I started talking about this, so not to get lost. I see Lee's emojis. Does that mean Lee's popped in? I can't see her, but maybe she has. I don't know. Okay, back to the document. Where are we? Where is it? There it is. Hello, wonderful to see your face. I only have a minute since it's dinner, but wanted to support you. I just discovered today you have YouTube Stupid X showing posts. Okay, thank you. I think I know who you are. In fact, yeah, I do. The picture tells me. Okay, thank you. Now, right, back to the document. Where's that document? There it is. Okay, where was we? Additional facts. As part of a voir dire. Okay, Lee, this is why we needed you, but no. Okay, the prospective jurors completed a questionnaire that included a question about whether they had friends or relatives in law enforcement. Prospective juror MB indicated that his son-in-law worked for El Paso County District Attorney. During follow-up questions, juror MB confirmed that his son-in-law worked as a deputy district attorney in the same office as and for Michael Allen, the elected district attorney of El Paso County and the prosecuting attorney in this case. Defense counsel later identified juror MB among the prospective jurors he wishes to challenge for cause. When the court asked for more detail, defense counsel explains his son-in-law works for Mr. Allen. The prosecutor in court then made the following comment. Prosecutor, I hate to agree with defense counsel, but the follow-up questions were never asked. How that's going to impact his ability to be fair and an impartial juror, and that certainly doesn't raise to a level of statutory cause. So we would object to him being released for cause. Court, yeah, I'm going to circle back on that one too. Probably what I'm going to do is not excuse juror MB at this point in time and think about it over the weekend and see where we are. I tend to agree that I don't think it's a statutory cause and don't hear anything else about that fact creating an issue or conflict or something else. I don't, I don't run across these sets of facts very often, so I just need to think about that one, and it may be that I decide it next week. Okay. The prosecutor suggested that the court ask further questions of juror MB, and the court agreed. Defence counsel objected. Okay. I think the record is what it is, and I guess the only thing I think that there is, you know, a difference between somebody saying I have a son or daughter who works for the police than I have a son-in-law who works for the DA who is actually trying the case. And so I think that's where it becomes different. Even if it was different, a different district attorney other than his son-in-law, direct boss who is trying the case, I think it would be different, and I'll leave it on that. So that's the defence's objection. The trial court brought the prospective juror back into the room and asked juror MB how long, where was we? His son-in-law had worked for the district attorney, whether juror MB had discussed the case with his son-in-law, and whether juror MB might be influenced by a desire to have the case work out better for his son-in-law. Based on his answers, the court instructed juror MB to return the next day. He was not ultimately dismissed. C. Discussion. Okay. The Attorney General does not dispute that juror MB fell within the category described by Section 1610, 103, 1B, because he was related within the third degree to his son-in-law, who was a deputy district attorney in the prosecuting district attorney's office. We are bound by Supreme Court's determination that his bias was implied by law. See Macranda 828 P2D at 23839. Nevertheless, Attorney General argues that the reversal is not warranted because it is not clear from the record whether juror MB deliberated. The Attorney General also asserted, what page? Okay. Also asserts that the defence counsel's challenge for cause was not properly preserved, and that counsel either waived or invited the trial court's error. We are not persuaded by these arguments. MB deliberated. Our review of the record demonstrates that juror MB deliberated. Indeed, the trial court granted Stauch's motion to settle the record at this point, removing any doubt. Challenge is properly before us. The Attorney General first argues that Stauch failed to properly preserve her challenge for cause because counsel did not explicitly cite, and then the number, and did not correct the trial court's purported misunderstanding that the challenge for cause was based on something other than statutory ground. The Attorney General further asserts that the defence counsel's comments on making the challenge for cause suggests that the challenge was based on juror MB actual bias, subject to rehabilitation, not his implied bias based on his relationship to prosecutor. For the reason discussed below, we conclude that the court considered, and then while the Attorney General attempts to dismiss this portion of the record as new material, the trial court ordered settling the record was accepted as part of the supplement record on appeal. It is therefore properly before us, and ruled on the statutory challenge for cause under section blah, blah, blah. Therefore, the challenge properly before us, sorry, the challenge is properly before us. To begin, we recognise that the Defence Counsel's challenge for cause potentially implicated two different subsections of section 16, 10, 103. Recall the statute requires the court to sustain challenge for cause on one or more grounds, including implied bias based on relationship with the attorney of record, subsection blah blah blah, blah and actual bias subject to rehabilitation. That is, defence counsel could have based this challenge on juror MB's relationship to the prosecutor or his state of mind resulting in that relationship. Given this context, we reach two conclusions from the record. First, we conclude that counsel stated reason his son-in-law works for Mr. Allen was sufficient in triggering ruling. The Attorney General frames their argument in terms of preservation, which directs our standard of reversal, but structural error generally requires automatic reversal without regard to whether the error was preserved. See People versus Miller. See also ID at Bender concurring. Nonetheless, in order for us to review the erroneous denial of challenge for cause, a challenge for cause must have been made. See the People, and then you got the case. Subsection 1B. Second, even if it were not clear solely from counsel's challenge to juror MB on which part of the statute counsel was relying, we nevertheless conclude the prosecutor and the courts. Nevertheless conclude that the prosecutor and the court's subsequent comments brought subsection 1B squarely into play for purpose of our review. See People versus Melendez, and then you got the case number. Talismanic language is not required to preserve argument for appeal, but the trial court must be presented with the opportunity to rule on that issue. As the prosecutor correctly observed, at the time of the challenge, neither attorney had asked any questions to elicit whether juror MB had state of mind evincing enmity or bias. Without these questions, there was no way to tell whether the juror MB should be excused for actual bias under section 60. Okay, well, that's the case number again. Having recognised this, the prosecutor continued to note that the challenge certainly didn't raise to a level of statutory cause. In this context, we conclude the prosecutor could only have been referring to statutory cause based on implied bias under subsection 1B. The trial court subsequently comments likewise suggest its awareness of the distinct for cause challenges available under, and then we got the case number, the subsection number. The court first said, I don't think it's a statutory cause, and then noted that it didn't hear anything else about that fact, creating an issue or conflict or something else. These comments indicate a cursory and improper rejection of challenge based on the relationship itself under subsection 1B, followed by a separate consideration and rejection of challenge based on the biased state of mind under subsection 1J. Despite the Attorney General's arguments, we do not read these statements as demonstrating confusion about the nature of Defence Counsel challenge. Instead, read it in context. We conclude the trial court statement. I don't think the statutory cause reflected the court's mistaken belief that juror MB employed bias based on this relationship to the prosecutor, based on his, should I say. Trial junkies, Paulie Warnock. I'll be coming back over to the chat in a second. Based on his relationship to prosecutor, as distinct from his actual bias as a result of that relationship, did not trigger mandatory removal under section. In other words, the trial court was not questioning whether the defence counsel was making a statutory challenge for cause based on the relationship itself. Instead, and critically for purpose of our review, we need the trial court statement as expressing its inclination to deny the challenge for cause on both grounds. Whether the trial court ruled on the claim raised on appeal, it is proper before us. People versus McPhee, case number. The defence counsel subsequent argument that the situation might be different if the juror's son-in-law worked for the police or for a different district attorney other than his direct boss who is trying the case, does not challenge the result, as the Attorney General acknowledges that argument went to whether juror MB should be excused for actual bias under the number again, and the trial court had already rejected the challenge under section again. As a result, defence counsel was under no further. Okay, so I'm going to stop there just so I can have a quick drink and see what you ugly mutts are doing. Let's scroll up because did I see something? There it is. There you go. Jinx, thank you very much for. Oh, there it is. 5 gifted memberships. Did we see who got them? Let's have a look. Scroll up, scroll up, scroll up. So Stephanie. Oh, Mark, as in the guy you know who I'm on about. Annie Lou. No, I remember that name. Irish girl. That's from years back. Gareth Wigglesworth. So they are the ones who got the memberships. Now let's scroll down. Oh, there we are again. Tormented Garen's mom. What's going on here? Okay. Tormented Garen's mom. Sorry, your ADHD, mild autism, my brain fires and skips words to type. Well, as you can tell by my reading, the same thing happens to me. Aurora says, hi, Paulie. So, oh, there's Paulie. What's up, cuzzo? Get out of it, you Philadelphia man. Hi, everyone. I got love for you all, but I want to love Frankie right now. Okay, Paulie. Okay, welcome. Welcome in. You can come in. Okay, where was we? Congratulations to the ones who got memberships, yeah. Yeah, if you're not already done it, smash the like, share, and subscribe. I'm paying attention, but you look at. I'll stop it. Trial Junkies is here. Trial Junkies is a massive supporter of covering missing persons cases and other things like that. So if one of the mods could drop hers and Sloothy's link, because Sloothy's right underneath her, so it'll save me saying it again. But yeah, she's been a massive support of the channel since she's found it, and I actually found her channel because she was covering a case actually up the road from me, from back when I was a child. No flirting with the host. Thank you for that rescue. Okay. Okay. Maybe don't put that in the chat, Paul. Uh, okay. But I think it's kind of cute too. But I'm also old enough to be his mom. Oh, stop it! You're only as old as the man you're feeling. Okay, back to the document. You guys are absolute filth. Oh, yeah, there's Trial Junkies if you want to check a channel out. She has a complete. I've never seen anyone do true crime the way that Trial Junkies does. It's really interesting and completely different. Like I said, Sloofy also has her own way, but we're not friends. Okay, where am I? The record further supports this reading. In addition to Juror MB, Defence Counsel's identified Juror number 8 among the jurors he wishes to challenge for cause. He explained that Juror number 8 had indicated that in his questionnaire that he could not be fair in a case involving child abuse, was not sure if he could set aside information he had heard about the case, believed a not guilty by reason of insanity plea was employed to excuse the alleged crime and was never asked about any of that. So, by contrast, when asked for his basis for challenging juror MB for cause, defence counsel simply said, "Yeah, his son-in-law works for Mr. Allen." Okay, it's all going on in here. Okay, obligation to restate his objection. See People versus Coughlin. Likewise, that defence counsel did not cite section. The number again is is of no moment. The Attorney General relies on People versus Cavalos Acosta, in which a division of this court denied to consider the denial of a challenge. Oh, my eye's gone. My eye's gone. Anyone got a spare eye? Denial of a challenge of cause. Challenge for cause, because defence. Oh, hang on, guys. Let me just pick my eye out. Oh, there we go. Really itching. Okay. Where was we? Defence counsel did not specify site section, but in Kevalos Ascot, defence counsel moved to challenge the juror for cause because he would place authority on the testimony of a police officer over anybody else, not based on the mere existence of a relationship covered by the statute. This case is distinguishable. Defence counsel initial challenge for cause subsequently stated that juror MB was related to the prosecutor, unlike Calavas Ascot. Counsel did not argue that juror MB might have actual bias in favour of prosecution, and as discussed, even if defence counsel comments left any doubt, the prosecutor and trial court expressingly acknowledged and dismissed the possibility of statutory challenge based on the relationship itself. On these facts, we conclude the trial court was on notice of a particular ground for the challenge, even without a specific reference to section See the People versus Kumar, an argument that goes to the subject matter of a statute without citing the statute directly sufficiently, preserves the matter for appeal. See People versus Cognac. Challenge for cause was preserved even though it was not expressly for cause, because the context made clear it was a challenge for cause. The error was neither waived nor invited. Waiver is the intentional relinquishment of a known right or privilege. People versus Rediger, we indulge every reasonable presumption against it. I'd invite error, by contrast, prevents a party from complaining on appeal of an error that the party invited or injected into the case. Uh, it is a narrow doctrine and applies to error in trial strategy, but not to errors that result from oversights. The Attorney General asserts that Defence Counsel waived or invited White Boy messaged me. The Attorney General asserts that the Defence Counsel waived or invited the trial court's error by failing to clarify the basis of the challenge for White Boy messaged, sorry. Basis of the challenge for after ruling suggests that the court was confused about the grounds for the challenge. But we have already concluded that the trial court's comments did not indicate that. Sorry, that was a bit waffled there, but we'll get back on track now. Sorry, if I show you all my notifications, you should be sick. You should be absolutely sick. Misunderstood the nature of the challenger for cause, only that it did not believe excusal or was warranted. Given this reading of the record, the foundation of the Attorney General's waiver invited error arguments collapse in any event, even after Juror MB answered the trial court's follow-up questions. Defence Counsel said, I maintain my objection to Juror MB. This is ongoing objection. Suggests there is no waiver, nor can we conclude that the Defence Counsel waived or invited the error by failing to use the preemptory challenge to excuse Juror MB. The law does not require criminal defendants to use preemptory challenges to preserve an unsuccessful challenge for cause. To the contrary, the Supreme Court has held that its prior decisions do not require a defendant to cure a trial judge's error on a challenge for cause by using the preemptory strike against the objection. Juror, in order to preserve a claim that this right to fair trial was violated by the presence of biased juror, Morrison versus People, emphasis added, People versus Garcia. The holding in Morrison indicates that there is no inherent inconsistency in allowing counsel to challenge a juror for cause while also permitting her to use preemptory challenges to excuse other jurors. We recognise that the majority of that case again declined to consider whether the waiver or invite error might apply in such situations because it was not raised on appeal. Nevertheless, the majority suggested, albeit in dicta, that even if there were to entertain an invite error argument, it would not find or invite error because the record did not suggest that the defence counsel purposely failed to use the preemptory challenge to remove the implementary bias juror ID. Simply, we see no suggestion of invited error here, and particularly in light of the defence counsel ongoing objection, see no suggestion of waiver on record. The Attorney General relies on Justice Samad Distant in Abu Natamu. Okay, there you go. expresses that the Defence Council decision not to use pre-emptory challenge to excuse a juror where are we? After the loss of for cause challenge is a classic example of waiver or invite error. Samoa J dissenting. Like Justice Samoa, the Attorney General suggests that counsel may simply request and trial courts may be encouraged to grant an additional preemptory challenge, but as in that case, the record here lacks any indication that the Defence Counsel was acting strategically. See Garcia. Finding no invite error under the same circumstances. Additionally, we are not persuaded that the Defence Counsel should be required to use a preemptory challenge to excuse a biased juror. After the court erroneously denied for cause challenge, moreover, nothing prevents the prosecution for using preemptive challenge to remove a juror who should have been excused for cause. Nor are we persuaded that the Defence Counsel may re-level the playing field simply by requesting an additional preemptory challenge. Our Supreme Court has consistently recognised the type of error implicated here, a violation of the defendant's right to an unbiased jury, as so harmful that it warrants an automatic reversal. See People versus Flockhart. Structural errors require automatic reversal without individualized analysis of how error impairs the reliability of the judgment of conviction. The harm arising from bias adjudicator pervades and infects the entire framework of trial. Citation omitted, sorry. And because maintaining the integrity of the judicial process is in interest not only of the accused but of the public. See People versus Nozzolino. We are not inclined to infer waiver from Defence Counsel failure to use preemptory challenge to correct trial court's error. Reversal is required when the trial court erroneously denies for cause a challenge for cause, whatever, to a biased juror. The defendant excuses her preemptory challenge and that the biased juror serves on the jury. The error is structural. See the case. The result of the legislator's determination that certain relationships render a potential juror employed bias, that the juror is deemed as a matter of law to be biased, period. Such is the case here. According to Stauch's conviction, must be reversed. Search warrant. Stauch also challenges the court denial of her motion to suppress evidence obtained for the search of her cell phone. Okay, we'll get some pop. Jesus Christ, Paulie. What's all that? Yeah, okay. Okay. So, let's have a look at the chat. What's going on? Oh, I know what I've done. I know what I've done. Jesus, Paulie, man. My chat's all you. Shorty makes sense. All of us actually care about the kids. What did Shorty say? Can't see what Shorty. Oh, there it is. Everybody's always so nice. This case is absolutely disgusting. Oh yes, crime kind of like to sprinkle my AirPods about. Teddy is quite a hero. Yep, smash the like, share, subscribe. Makes sense. All of us actually care about the kids, yeah, and not the defendants. That's me saying that, not Peacock. Lesson for all: I'll lose an AirPod. Okay. I love my babies, and they are 46 and 40. I mean, you say this, look, Paula, you say it, and then I look at my chat, and it's all you. What's this? Okay, okay. Okay. He smuggled out of Colorado in his prison purse. Yeah, consider becoming a member. It helps support the channel. It helps me spend time on with the families. And like I said about my notifications, guys, just look at this. Let's get that one off. This is all my notifications. These are messages from family members that I was talking. Oh, some of them are actually. But yeah, these are all family members that I've just been talking to before the live, and then you've got underneath there people trying to talk to me as well during the live. It's and then all you got all like the Facebook notifications and things like that. It's going off. This is a lesson for all judges to ensure the jury is not questionable. Yeah, well, that's the job of the judge, isn't it? The judge's job is to make sure the conviction is airtight, and we're seeing time and time again that that's not the case. Not in every case, not in every case, but we are seeing it quite a lot. Okay, where are we? Although Justice Simone's dissent suggests that encouraging, I totally get rules and laws so you don't end up with jurors accepting that are biased. But my problem is that this was known at the time. Yeah, but what they're saying is it wasn't acknowledged, as in they kept ignoring it. So the defense was just like, okay. And so they've gone back, and now we're on to the search warrant. Although Justice Simone's dissent suggests that encouraging judges to grant requests for additional pre-emptory challenges under crime would re-level the playing field, that case, we are not sure. After all, defence counsel would necessarily premise that a request for additional pre-emptory challenges on the court's prior wrongly denied challenge for cause ruling made by same judge, and we are not confident that the same judge would grant additional preemptory strikes on this basis. Because this issue is likely to impact the proceedings on remand, we elect to address it. In denying Stauch's motion to suppress the trial court, acknowledged that the warrant to search Stauch's cell phone was broad, but concluded that its breadth was necessary. Was necessary. Given the scope of Stauch's conduct after GS went missing, Stauch argues the court erred because the warrant violated the Fourth Amendment, particularly requirement to discern no error. So let's click on this. Big Brother ignored the rules and law on purpose when they stopped getting tarred and feathered. They stopped fearing the mass public see us as plebs. All government, not left versus right issues. Yeah, I got that. I got what you're saying there. Now, where's my document gone? Why isn't the U-Haul checked? Why wasn't the U-Haul checked? Well, it's a case if they've got to get the warrant for it. But they had enough evidence anyway. The case was airtight, and it's a stupid error on the judge. Something so silly, which she should have just done the error for cause. Even if she wasn't going to dismiss the juror, she can claim that she did it and found no reason. But she didn't do that. It's kind of like in Delphi when Judge Gull should have just held that hearing with the defence team. Because she didn't, it granted them to come back. Aurora, because the judge thought that after speaking with her, she could be fair. My question is, why would they risk it? Exactly, trial junkies, Z, should I say? Knowledge that the warrant to search Stauch's cell phone was broad, but concluded that the. Oh no, we've already read all this. Sorry. Where are we? Applicable law. The Fourth Amendment protects the individuals against unreasonable searches and seizures. U.S. Constitution Amendment. A search conducted pursuant to a warrant is typically reasonable. People versus general warrants, which permit a general exploratory rummaging in a person's belongings, are permitted. Quoting Anderson versus Maryland, to prevent a general exploratory search, a search warrant must be sufficiently particular as to enable to executing officer to reasonably ascertain and identify the things to be searched. People versus Rodriguez or Ortez. Because cell phones, we're getting there, contain so much different types of private data, warrants to search them must be, what's the time? Okay. Must be carefully scrutinised, see Coke, to be sufficiently particularised. Warrants for the search of data on cell phones must include specific limitations based on 1. The type alleged crime activity, 2. The identity of the alleged victim, and 3. The time frame, if applicable, within such a suspected crime occurred. Rodriguez Ortiz. When evaluating whether a warrant is sufficiently particular, we must look into the totality of the circumstances, reviewing the warrant and any accompanying affidavits in a practical, common sense fashion to determine if probable cause exists. Quoting People versus Rocafort, even if a warrant lacks particularity in its face, an affidavit submitted in support of a warrant may cure its lack of particularity. The defendant's the deficient warrant incorporates the curative affidavit by reference. 2. Both documents are presented to the issuing judge or magistrate. The curative affidavit accompanies the warrant during the execution of the warrant. A trial court suppresses order presents a mixture of questions, fact, and law. We accept the court's finding of fact if they are supported by competent evidence, but we assess its legal conclusion de novo. B. Additional facts. The investigative sought a warrant to search Stauch's cell phone for the following: data that may identify the owner or user of the devices, address books and calendars. Audio and video clips related to the above described crime activity and further described in this affidavit in support of the search warrant. Sales history, call logs, and voicemail related above described crime activity further described in this affidavit to support their search warrant. Photographs, associated metadata related to the above described criminal activity and further described in this affidavit in support of the search warrant. Text messages, SMS, multimedia messages, SMS, recorded messages, and subscriber information modules, SIM cards between the cell phone owner and co-conspirators involved in above described criminal activity further described in this affidavit in support of the search warrant. The above described items, email messages, and attachments, whether read or unread, related to the above described criminal activity and further described in this affidavit in support of the search warrant for the above described items. Internet World Wide Web browser files, including but not limited to browser history, browser cache, stored cookies, browser favorites, autocomplete form history, and stored passwords. Global position systems, GPS data, including but not limited to coordinates, waypoint, and tracks, documents, and other text-based files related to the above. There's another family. Described criminal activity and further described in this affidavit in support of search warrant for the above described items. Applications and other installed programs, including widgets and any data stored by the application or remotely stored by application server or database server. Any and all computer software to include but not limited to operating systems, applications, utilities, compilers, interpreters, communication programs, or any other digital information which can be interpreted by a computer or any related component which may be stored in electronic, magnetic, optical, or other digital form. Any and all data stored within any computer storage device or other processing and or storage devices include but not limited to computer applications, images, videos, text programs, encryption routines, and algorithms, or any other data that may be decoded, reconstituted, or otherwise manipulated to produce, utilize, transmit, receive, encrypt, encode, or display such images, videos, text programs, encryption routines, and algorithms. With respect to those items, the warrant authorised police, with the aid of law enforcement, I thought that was the same thing. There we go. Computer forensic laboratory to view, photograph, record, copy, forensically image, and conduct forensic analysis of any and all metadata, programs, and applications on above described devices, as well as any data storage devices and or mediums attached or installed in those devices. The warrant incorporated an affidavit detailing GS's disappearance. Let's put some hearts and his name in the chat, please. And Stauch's conduct thereafter, including Stauch's refusal to cooperate with police, conflicting statements, behaviour, ongoing communication with family members and social media posts. The affidavit submitted that it is necessary to search Stauch's cell phone to ascertain her past location and communication and aid in locating GS, who was still missing at the time. Discussion. Stauch argues that the warrant to search her cell phone was overboard because it allowed police to access anything that might be on her phone with no temporal limitations. While she acknowledges that the affidavit was incorporated by reference into warrant, she argues that it is broadened the, the scope search even further by allowing the search for anything that could be used as evidence against her. We disagree. True warrant itself did not describe the type of alleged criminal activity, identity of the victim, or time frame within which the crime occurred, but it specifically incorporated the warrant application and supporting affidavit that did. The warrant limited the search to the items specified in the application. The application, in turn, attached 4-page supporting affidavit and made it part hereof. The affidavit describes how on January the 27th, 2020, Stauch called to report GS missing, stating that he had left her house on foot and had not returned. It continued to describe how during the subsequent 40-hour period, Stauch refused to meet with the police or provide requested information, was unaccounted for during part of the day GS was reported missing, called in sick to work for an unrelated reason, and had been continuously communicating with her daughter, husband, and other family members via text messages and Facebook. The affidavit also described that Stauch met with police 2 days after the report when she subsequently challenged her statement regarding GS's disappearance. Stauch initially suggested GS went to a friend's house and didn't return, but the police station, she said that he was abducted by a carpet repair person who had sexually assaulted her at gunpoint. The affidavit went on to describe a roll of carpet with blood on it that was found in a storage area inside Stauch's house. It also stated that Stauch's cell phone was linked to her doorbell camera security system. Based on its specific incorporation of the affidavit, which signed by the issuing magistrate and accompanied the search warrant during its execution, we conclude that the warrant was sufficiently particular. See Rodriguez Ortiz. Stauch argues otherwise based on Coke 38, in which the court found the warrants insufficiently particular because it contained no limitation as to the alleged victim or time period during which the crimes occurred, but described above, the warrant affidavit here specifically describes Stauch's conduct during the 40-hour period after GS went missing. C. Rodriguez versus Ortiz. Cell phone warrant was sufficiently particular because it incorporated affidavit describing period investigation. While warrant was broad, the affidavit was specific. It described the conduct limited to those 40 hours, clearly identified GS as the victim, and detailed inconsistencies in Stauch's conduct and story in the aftermath of his disappearance. CID. The fact that the warrant was broad was not dispositive when it covered a 6-month period. The affidavit identified the victims and specific crimes and the defendants conduct and communications surrounding the crimes were relevant in identifying him as the suspect. More after many of the categories described in the warrant were expressingly limited to items related to the above described criminal activity further described in this affidavit. While not every category included the same limiting language, the warrants incorporated that the attached affidavit served the same function. ID at 34, warrant satisfied the particular requirements on this basis, even if it could have been more particular. Because the warrant and affidavit read together limited the search of Stauch's cell phone to a specific time frame, victim, and type of criminal activity, the warrant did not allow for a general search, instead targeted specific set of data that allowed police to establish Stauch as a suspect. See Rocco Fort. A broad search warrant is nonetheless permissible when the requested evidence is justified by the nature of the crime or crimes. We therefore conclude that the Fourth Amendment particularly requirement was satisfied and Stauch's motion to suppress was properly denied. Because we conclude that the warrant and affidavit were sufficiently particular, we do not address whether the good faith exception applied. See People versus Rodriguez Ortiz. Cert granted February 9th, 2026. Suppression based on the overboard warrant is not required when officers act in objectively reasonable reliance to a warrant issued by a neutral magistrate. We also decline to address Stauch's remaining evidentiary contention because it is unclear whether or how that issue will arise with on remand. See, remand in the UK means something completely different, but disposition. The judgment is reversed and the case is remanded within directions Judge Gomez concurs. And then it's blank. Lovely and blank. We can draw pictures on this one. We can write she's a dickhead. Anyway. Judge Bernard, concurring in part of dissenting in part, assume a court erroneously denies a defendant challenge for cause to hypothetical juror A, then assure the court also denies the defendant's challenge for cause to hypothetical juror B, C, and D, E, F, G, and H. Next, assume the defendant has 16 preemptory challenges. She uses 7 of those preemptory challenges to remove as jurors B through to through to H from the jury, and the other 9 challenges to remove prospective jurors whom she did not challenge for cause, but she does not remove juror A, who sits on the jury, ultimately convicts her. In this situation, does she waive her right to contend she is entitled to a new trial because of the court's error? I would answer question yes. Because the majority answers this question no, respectfully, dissent from the portion of Part 2, C3, the majority opinion, concluding the defendant's Letecia Stauch did not waive the error the trial court made when it denied her challenge for cause to juror MB. I concur with the majority's determination in Part 2, C3, that court erred when it denied that challenge, with the majority analysis of further amendment issue in Part 3C. Okay. Can we quickly have a drink there? you're brave reading all this. I legit was the kid who sat at the back. Sloopy, that's me. That is genuinely me. Uh, this is like, since doing this channel is like the first time I've ever actually read out loud. Jinx, that was why I turned my camera off the other day. Yeah, normally I would as well, but I'm too far ahead. I also address the issue the majority does not discuss. Did the trial court when it allowed the prosecution to present evidence concerning the defendant's prior manipulative behaviour to rebut her defence of not guilty by reason of insanity? You are doing great, thanks. Thank you. Because I do not believe the court erred, I would affirm the defendant's convictions. The interplay of challenge for cause, preemptory challenge, and waive doctrine waiver. Structural errors, even those impinging the fundamental constitutional rights, can be waived. Stackhouse versus the people. A defendant can waive her rights to a public trial, ID at her right to challenge a prospective juror who was the wife of the judge presiding over her case, Richardson versus the people, and her right to object to a judge persisting over her case who had, while working as a public defender, previously represented her, People versus Garcia, and by pleading guilty, she waives a number of constitutional rights, including some that could lead to structural error if erroneously denied, such as the right to trial by jury to a public trial, People versus Jennings. Waiver is intentional relinquishment of a known right. Forget versus People. Waivers may be implicit when, for example, a party expressly abandons the existing right. ID waivers may be also employed when the party engages in conduct that manifests in intent to relinquish a right or acts inconsistently with its assertion. When deciding whether a waiver was employed on, the record needs only show that the defendant or counsel made a conscious decision to forego raising a claim or an objection for strategic other reasons. Cardman versus People. We do not presume acquiescence in the loss of fundamental constitutional rights, and we therefore indulge every reasonable presumption against waiver. People versus Curtis. Okay, that was when you saw the numbers. A short history of preemptory challenges in Colorado. The United States Supreme Court has long recognized that preemptory challenges are auxiliary, unlike the right to an impartial jury guaranteed by the Sixth Amendment. Preemptory challenges are not of federal constitutional dimension. United States versus Martinez Salazar. See also Rivera versus Illinois, or Illinois, as these guys say. I'm not a Yankee, I'm afraid. If a defendant is tried before a qualified jury composed of individuals not challengeable for cause, the loss of preemptory challenge due to state court's good faith error is not a matter for federal constitutional concern. The way Colorado courts view preemptory challenges has challenged changed significantly over the last quarter century. By 2014, a Supreme Court required the reversal of any criminal conviction in which the defendant used a preemptory challenge to remove a prospective juror following an erroneous denial of her or him challenge for cause, and ultimately exhausted all preemptory challenges available to him. People versus Novotny. In 2000, the Supreme Court expanded the scope of this automatic reversal rule to include erroneous grant for prosecution challenges for cause. Reason for that, such error gave the prosecution an unfair tactic advantage. But in Novotny, our Supreme Court abandoned the automatic reversal rule because both federal and state law governing harmless error review in general. I was this dude. Okay. Okay. So where was he? Because both federal and state law governing harmless error reviewed in general and the lack of constitutional significance and preemptory challenges in particular have developed so as subsequently erode the premises upon which the automatic reversal rule rested. The court replaced the automatic reversal rule with an outcome determinative rule based on the harmless error standard of CRIM P 52A. An error will be disregarded unless it affects subsequent rights, which requires evaluating the likelihood that the outcome of the proceedings in question were affected by error. Under the harmless error standard, if a juror is biased against the defendant sits on the jury, such an error is structural because it violates the defendant's right to impartial jury, and appellate court must therefore reverse the defendant's conviction. People versus Abu Nanatumbu L. It's okay. I lived up in Chicago once. Illinois is one of those weird words. At times I said it wrong. Doc would laugh at me. God damn you, Doc. You have heard me try and say some UK term. Yeah, that's true. Okay. Yeah, so that's 1-1 for me and Troll Junkie. The majority of Novotny did not address the scenario we face in this case. Does a defendant waive the error if she uses all her preemptory challenges, but she does not use one for them to remove a juror whom she challenged for cause? The trial court erroneously denied that challenge. We discussed the issue next: preemptory challenge and waiver. So, preemptory challenges and waiver. Some might say that at least under federal law, the issue in this case has already been decided by the United States Supreme Court in Martinez Salazar. The government urged the Supreme Court to read federal law to require the defendant to use a preemptory challenge to strike a juror who should have been removed for cause, in order to preserve the claim that the for cause ruling impaired the defendant's right for trial, to a fair trial. 528 US at. Okay, the Supreme Court rejected this invitation, reasoning there was no federal law demanding that the defendant use or refrain from using a preemptory challenge on a particular basis or when a particular set of facts is presented. The court recognised that there is one obvious expectation to the statement. The Equal Protection Clause prohibits yeah, of the exercising a preemptory challenge for, to remove the potential juror solely on the basis of juror's gender, ethnic origin, or race. ID at 315. This language, some would suggest, shows the United States Supreme Court rejected the application of the waiver, the doctrine, in the situations such as in this case. But I submit there are three reasons why Martinez Selza did not do so. Second, second, in concurring opinion, Justice Scalia pointed out that the issue before the Supreme Court was not whether a defendant should be required to use preemptory challenges curatively or when a trial court has erroneously denied a challenge for cause. Martinez Salazar Scalia concurred that the judgment, rather the issue was whether the defendant's actual use of a preemptory challenge to effort such a cure impinging upon the ability to exercise all these preemptory challenges under Fed R. Crim, and the majority had concluded the exercise of defendant's preemptory challenges had not been advisory affected. Justice Scalia was far from certain that the court's analysis of the use of preemptory challenges was correct. It is easy enough to agree, he continued, that we have no warrant to read into Fed R. Crim 24B a requirement that preemptories be used to remove a Venierman properly challenged for cause. The difficult question, however, is not whether Fed R. Crim requires exercise of preemptory, but whether the normal principles of waiver disable the defendant from objecting on appeal to the seating of a juror he was entirely above to prevent. Martinez Salazar 528 US Act 318. Scalia concurring the judgment. He then added, I would not find it easy to overturn a conviction where, to take extreme example, a defendant had plenty of preemptories left, but chose to instead allow to be placed upon the jury a person to whom he had registered an objection for cause, and whose presence he believed would nullify any conviction. Let's have a look at the chat. Oof, we're getting some breaths in. Right, where was I? Frank always does a good job. Did someone say something different? No fighting. Frankie's my good friend, and someone says something bad about him, I'll defend him. So I'm double dog there anyway. Okay, calm down. Thank you, Joy Small though. Jinx backs me up as well. Yeah, come on then, boys, fight me. I don't drive. I'm terrified. Instant visions of Rex. Oh, okay. Did I miss something? Am I being held hostage in Top Chat again? Thank you, Frank. You're doing great. Thank you, Karen. It's very nice, yeah. Is that? Yeah, that's it. Okay, so back to the document. Keep going, keep going. We can. Oh, I've pressed need help. I don't need help. Oh, I don't want you. Why did you do this to me? Okay, here we are. Oh, let's get this over here for starters. Third, Martinez Salza concerned a rule of federal criminal procedure, not a rule of state criminal procedure. See Browning versus State, 2006, OK, CR 8. While Martinez Salza is the law in cases involving federal criminal procedure, it is not law which requires any change of cause from this court. See also State versus Talbot, Wash 2022. The part of Martinez Salza pertinent to issue is not based on any legal principle that applies to state. Denby versus State 322 SO 2D 563 584 and 9 FLA 2001. Lawson J. Concurring in part that and concurring in the result may have left open the issue of whether, under federal law, normal principles of waiver disable a defendant from objecting on appeal to seating of a juror. He was entirely able to prevent through the use of pre-emptory challenge, quoting Martinez Salazar 528 US at 318. Scalia J. concurring that the judgment State versus Lindell, the Martinez Salazar opinion applied in the federal cases constitutional ruling controlling state courts. There are potential Colorado counterpart to Martinez Salazar. Shortly before Martinez and Salazar came out, a division of this court decided People versus Morrison, Aft 19. The division concluded because the defendant chose not to excuse the juror in question by use of a preemptory challenge, the court's denial of his challenge for cause did not have effect of reducing the number of preemptory challenges that he could exercise, ID at 3. As a result, the defendant failed to demonstrate how the court denial of his challenge worked in prejudice upon him. About 5 months after Martinez Salazar was decided, our Supreme Court affirmed the division's decision in Morrison versus People 19P 3D 668 670 Colorado 2000. Albeit on different grounds, the Supreme Court's opinion is unspooled like this. We hold that the trial court did not abuse its discretion in denying the defendant's challenge for cause because the juror in question stated that she could fairly hear the evidence, ID, because the trial court did not commit any error concerning this juror. We need not base our decision on how the defendant responded to what he perceived to be an erroneous denial for challenge for cause, ID, emphasis added. God damn you, notifications. We consequently find it unnecessary to determine whether the defendant suffers an impairment of his right to use preemptory challenges if he exhausts his preemptory challenges but does not use one of his challenges against a juror who he originally challenged for cause, emphasis added. Such a scenario and controlling question is whether the defendant's constitutional right to an impartial jury was violated by presence of a biased juror on his jury ID. As a result, the division's relation incorrectly relied on our Supreme Court's precedent because those decisions do not require a defendant to cure trial judge's error on a challenge for cause by using the preemptory strike against the objectionable juror in order to preserve a claim that his right to a fair trial was violated by presence of a biased jury on his jury, a biased juror on his jury, should I say. ID cites Martinez Salza. The court wrote that regardless of whether the defendant chose to use a preemptory challenge on the allegedly objectionable juror because he challenged the juror for cause and she served on the jury, his right to an impartial jury was violated if his challenge for cause was improperly denied. Morrison 19p 3d at 671. The opinion proceeds to discuss whether the record shows the trial court had erred in when it denied the defendant's challenge for cause, ultimately concluded the trial court had not erred, ID 67172. Fast forward 19 years, in which the trial court erroneously denied a challenge for cause based on section, we've seen it before, CRS 2025. The majority described the issue in that case to be as follows: what standard of reversal applies when the trial court erroneously denies a challenge for cause? The defendant exhausts his preemptory challenges and the challenge juror ultimately serves on the jury. The majority answered the question this way: we conclude that the erroneous seating in the impliedly biased juror is structural error and requires reversal. As a result, such an error, I've lost it, what have I done? Such an error is not amendable but analysis under the harmless error standard, regardless of the juror's actual bias. The majority do not address the issue whether the waiver doctrine applied to those circumstances because the prosecutor had not raised the issue, ID at 38N7. Justice Samore dissented after arguing that the juror was biased and should not be allowed to serve. Justice Samore wrote, the defendant turned around and elected not to excuse her with one of his 12 preemptory challenges. Samore J dissenting. As a result, Justice Samore thought the defendant had either waived or invited the error, but Justice Samore asked, would one unfair shortcoming of his approach be defendants always losing? Had this covered encouraging trial court judges to grant a defendant's request for an additional preemptory challenge? So whenever they deny a colorable challenge for cause, one that is difficult to resolve and presents a close call. Okay, so here we are into the analysis. But first of all, I'm going to have some water. I say water, but this. And You are right, Charles. I just caught that. Prosecutor should have known better. The thing is, I mean, it's a catch-22. We all know she's guilty, but she deserves a jury of her peers and an impartial one. Colorado sucks. My heart breaks for Gannon's family being put through all this over again. Correct. I love it. Again, smash the like, share, subscribe if you haven't already. It helps the channel. It helps the cases. And there we go. We all love Frank. Thank you, Shorty, Karen. Yeah, so said that they're going to go through it again. Agree. Letecia and Gannon and his family don't deserve to go through this again. So I didn't know it was flashing like that on the screen. It's not doing it on my side. Okay, so the next one. The prosecutor should have known better, which is correct. But they have to go through all these arguments in the preliminaries and all that, and that's why, so it doesn't happen during the trial. That juror will never be able to be on a jury as long as her son-in-law has a job. Yeah, well, yeah. Even if she wasn't biased, it was how it looked. Yeah, that's correct. Well, like it said earlier on, there's a law in it. It should have been automatically challenged. This could have been avoided so easily. So now the family has to go through all this whole case. They should have at least looked at the. You know what I mean? They should have at least looked at all these. It looks like they went to look at it, and she said, "I'll come back to it," and she never actually did. You wonder if the daughter will testify again. Poor daughter. Yeah. Sorry if it felt like I was shouting at anyone. Okay, we're nearly there, guys. Analysis. I conclude further reasons. The following reason: defendant waived the error the trial court made when it denied the challenge for cause juror MB. She waived the error because she did not remove juror MB with preemptory challenge, although she had 16 available to use for that purpose. I mean, that is right. That is right. But they still sat. The issue is preserved, unlike the prosecution raised the issue of waiver in the answer brief in this appeal. The issue had not been decided. Okay, so quick announcement from Frank Meister. He's not well. He's had a diabetic attack, and he's going to disappear for a few days. So, thoughts and prayers with Frank Meister. Okay, so the prosecutor raised the issue. The issue has not been decided in Colorado. Martina Salza only applies to federal cases. See Browning, Talbot, and all that is. Larson J concurring in part and concurring in the result. Morrison did not resolve the issue either. The Supreme Court stated it need not base its decision on how the defendant responded to what he perceived. Being erroneous denial of challenge for cause. The court also said it is unnecessary to determine whether the defendant suffers an impairment of his right to use preemptory challenges if he exhausts all his preemptory challenges, but does not use one of his challenges against a juror who originally challenged for cause. Our Supreme Court resolved the appeal by concluding the trial court had not erred when it denied the defendant's challenge for cause. Harkening back the Justice Scalia concurring opinion that Martinez Salazar Morrison's discussion of not requiring a defendant to cure the judge's error on a challenge for cause. Well, no, why would any defence do that? That is the perfect little hot potato sitting there because they know they're going to lose the case. By using preemptory challenge was a dicta, see, some more dissenting. Morrison was decided 14 years before Novotny. So, as an artifact of the era of automatic reversal rule, it is unclear how much of Morrison's reasoning is still viable since it was rooted in now discarded rule. And in Abu, our Supreme Court stated that this issue has not yet been decided. See People versus Verjaria. I am aware that the division in People versus Garcia stated Morrison's holding was in part that its previous decisions do not require defendant to cure trial judge's error on challenge for cause by using preemptory strike against the objectable juror in order to preserve a claim that his right to a fair trial was violated by the presence of a biased juror on his jury. Quoting Morrison, relying on this holding, the division rejected the prosecution's invite error contention CID at 8. But I think the division put more weight on the on the quoted language in Morrison that the language bears because it was dicta. See Abu. Samor J dissenting. In any event, I am not bound to follow Morrison's division reasoning. See People versus Smoots. One division of the Court of Appeals is not bound by the decision of another division. Aft sum nom Reina. Where's that gone? Abarca versus People, and then the case number, or whatever that is. Requiring parties to use preemptory challenges to cure jury selection errors is a good idea whose time has come in Colorado. It is a general rule that all matters pertaining to the qualifications and competency of the prospective jurors shall be deemed waived by all parties if not raised prior to swearing in of the jury to try the case. Crim P24B2. So if a defence attorney waives any error related to challenge for cause by not making the challenge in the first place, or if the attorney waives the same type of error by not excusing the preemptory challenges allotted to the defendant, see Vergira. Someone thought Vergira. Then how does that same lawyer preserve the error by making the challenge for cause, having it erroneously denied, and then failing to remove the juror with an available preemptory challenge? William T. Pizzey and Morrison B. Hoffman, jury selection errors on appeal, 3/8 AM, Crim L. Rev. 1391143 2001. Why should two of these acts not be making a cause challenge at all, or not exhausting all available preemptory challenges to be subject to the waiver doctrine, while the third not using preemptory challenge to cure the erroneous ruling on a challenge for cause, not be subject to the doctrine. In the third situation, the lawyer had the power to remove the biased juror, elected not to do so, and now wants to complain about the election on appeal. The issue is there. I agree. The defence lawyer should have done that. But again, why is a defence lawyer going to do the judge's job when that's their little hot potato, when they've got a case that they're going to lose? This is especially true because when looking at the relationship between challenges for cause and preemptory challenges, the history of these two types of challenges indicates preemptory challenges have always had curative purpose. There are sufficient institutional costs to rejecting the application, the waiver of doctrine in cases such as this one. I mean, I guess my argument there would be the judge should have highlighted, if the judge had said, you can use one of your preemptories, and that was on record, I can't see there being a problem. The judge never said that, so therefore that's not on record. So therefore the defence played a blinder, sadly. The salutary purpose of a contemptuous objection, contemporaneous objection rule are particularly important in jury selection. We want to encourage the trial court's opportunities to correct jury selection error for the very reason that we are at the beginning of the whole process. There are obvious and enormous judicial economies in correcting jury selection errors when they are made rather than within appeal and retrial. By electing not to remove biased jurors preemptory, defendants particulate in their seating every bit as much as the trial judges who erroneously fail to remove them for cause. Correcting the trial judge's error is not hard. The defendant is in a position to correct the trial judge's cause error early and easily, simply by using the available preemptory challenge to strike the problem juror, ID at 1436, and this remedy is far superior by any legitimate institutional measure to letting the biased juror sit through the entire trial, then reversing the conviction, ordering a new trial. Martinez Salza did not suggest that the state prohibited or even discouraged from requiring parties to cure alleged jury selection errors with their preemptory challenges. Talbot 521 P3D at 956. Indeed, there are good reasons to require parties to use their available preemptory challenges to cure jury selection errors. Doing so prompts the defendant's rights to receive a fair trial in the first instance and prevents unnecessary retrials. Encouraging trial courts to be open and granting additional preemptory challenges when the decision to deny a challenge for cause is a close one would cure any unfairness created by the application of waiver doctrine. Crimpy 24D3 states, for good cause shown, the court at any time may add preemptory challenges to either or both sides. I agree with Justice Samor's suggestion in his dissent in Abu Matabu. Samor J dissenting, where are we? That we should encourage trial court judges granting the defendant requests for an additional preemptory challenge, whether they deny a colourable challenge for cause, i.e., one that is difficult to resolve, presents a close call, the defendant could then use the extra preemptory challenge to remove that jury. That remedy would, one, classify the denial of a challenge for cause that is difficult to resolve and presents a close call, ID, as good cause for granting an additional preemptory challenge under CRIM P24D3. 2. Eliminate the reversible error if the defendant uses the extra preemptory challenge to remove the juror she previously challenged for cause, even if the court erred when it denied the challenge because it was based a biased jury would not have served on the defendant's jury. 3 means that the defendant would waive their ability to challenge the trial court ruling on the challenge for cause on appeal if she did not use the extra preemptory challenge to remove the jury previously challenged for cause. Require the appellate court to reverse the defendant's conviction if the defendant asked for additional preemptory challenge. The trial court denied the request. The juror who had been unsuccessfully challenged for cause served on the jury, and the appellate court concludes the court erred when it denied the challenge for cause. Disincentivize the prosecution from opposing colourable. Okay. Yep. Challenges for cause. Samoa J dissenting, and 6. Give trial court judges some comfort in knowing that the additional preemptory challenge could cure erroneous denial for colourable challenges for cause, ID. Okay. Even if the defendants should not be required to use preemptory challenges to cure jury selection errors, the defendant nonetheless waived her right to challenge the trial court's decision to deny her challenge for cause, juror MB. Okay. It is my view that this case represents Justice Scalia's extreme example. Martinez Salazar, and that will case number. Scalia concurring in the judgment, which I believe is not as unusual as Justice Scalia for. Defendant knew she had challenged challenged juror MB for cause, and why. She used all 16 of her preemptory challenges, including 7 of them to remove other jurors whom she had challenged for cause. Yet, although she was obviously aware she could use any one of her 16 preemptory challenges to remove juror MB from the jury panel, she chose not to do so. She therefore knew juror MB would remain on the jury panel, and she did not ask the trial court for an additional preemptory challenge under CRIM P24D3 for the express purpose of removing juror MB. MB, you're in a lot of trouble, mate. I conclude this combination of awareness and deliberate conduct was intentional. It was not implied waiver of defendant's rights to challenge the trial court's erroneous decision to deny her challenge for cause to juror MB on appeal. Defendant could have cured the trial court's error, but thought her counsel she engaged in conduct that manifested an intent to relinquish her right to remove juror MB from the trial forget 28, which amounted to the conscious decision to forego her right to challenge the trial court error on appeal. Cardman 18N6. C. Martinez Selza 528 US at 31819. Scalia J. concurring in the judgment. Okay. Now I turn the remaining appellate issues to the majority. The majority does not address. Testimony about manipulative behaviour. Defendant asserts trial court erred by allowing the prosecution to rebut her insanity defence by introducing evidence showing she had previously been manipulative. I disagree. That was the document, not me. Don't come after me. See, look, I disagree. It wasn't me that disagreed. Defendant objected to the evidence, adding the court should analyse it under CRA 404B. The prosecution replied that the evidence was relevant to the defendant's mental condition. The court decided CRA 404B did not apply. I will assume, for the purpose of discussion, the manipulation evidence was a form of bad act evidence, yet I would nonetheless conclude the court did not err when it admitted it. Before Colorado switched to its present unity trial system, the law bifurcated sanity and guilt trials where defendants plead not guilty by reasonable of insanity. Generally, evidence of prior criminality of an accused is not admissible. However, in a bifurcated insanity trial, this rule is relaxed since the prejudice that may occur by the admission of such evidence is lessened by separate trial on the issue of guilt. People versus Bieber, not Justin. 835 P2D 542 546 Color App 1992. Citation admitted. Aft 856 P2D 811 Color 93. Courts in other states have decided that the defendants, by pleading not guilty by reason of insanity, make much of their entire life history relevant. See State versus Hurls. We're not going through all that again. People Hauser, all that again. People versus Woody, Mitch, 1968. People versus Santarelli. Again, I'm not going through all that again. Beautiful though, isn't it? All them numbers. I'm not doing it. I'm not doing it. I refuse. Okay. 2 more pages, guys. I therefore conclude that the evidence of the defendant's manipulation would throw light on way or the other. So basically say it could go either way. On the issue of the defendant's sanity, Hurls, blah, 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 citation admitted, and that it would strain the rules of evidence to hold that the prosecution is precluded from including evidence to counter the defendant's claim of insanity solely because the evidence involves the defendant's previous immoral and unlawful conduct. Santarelli. There we go. All them numbers. Oh. But what if the reasoning does not apply to Colorado's present unity trial system? Even if I thought the trial court's decision not to apply CRE was an error, I do not think it is reversible error. A conviction will not be overturned on appeal when the trial court used an erroneous standard in analysing the admissibility of evidence. If the evidence was admissible and the proper foundation was laid for the admission, People versus Cousins, numbers again, we're not going there. The record supports the determination, the manipulation evidence and admissible under CRE 404B under the four-step tested announced in People versus Spotto, all them numbers. The evidence could the evidence related to the material fact of whether the prosecution could prove beyond a reasonable doubt the defendant was sane at the time of the crime was logically relevant to this material fact because it provided basis for testimony that some of the defendant's conduct was manipulative, meaning she was malingering. Her claim of mental disease or defect had logical relevance dependent of prohibited interference that the defendant committed the crime on account of her bad character because it gave the jury information with which to assess the validity of her insanity defense and at probative value that it was not substantially outweighed by the danger of unfair prejudice, CCRE 403, because defendant's manipulativeness did not have an undue tendency to suggest a decision on improper basis, commonly but not necessarily an emotional one, such as sympathy, hatred, contempt, rehabilitation, or horror. People versus James, not reading the numbers. Quoting Masters versus People, the numbers. Accordingly, I would affirm the court's convictions. Oh my God, we did it. We did it, guys. Oh, we did it, guys. It's going to make me big. I knew it. Okay, let's scroll up and have a look what you horrible that I've been saying. Okay, yeah. Oh, Susie, have you fed your husband? Doubt it. Scroll up. Well, yeah, but after the doctor, we'll still give you a checkup. Frank Monster's been working out, probably forgot about it. Yeah. Frank Meister, sorry, I got a notification. He's written a message, so let's just hope that he's all right. Plenty of rest and balancing it out should sort that out for him. Regardless of that, we wish him well. Don't duck the doctor. Okay. Well, yeah, but okay. Jesus Christ. Oops, I'm late. Yeah, you are. So I hope your husband has had 2 teas. Yeah, he's had 2 meals. Okay. Hi, Susie. Smash the like if you haven't already. Okay. Okay. Anyone got anything to say? I mean, yeah, it's not the decision we want. We hate the fucking woman. Let me because I want to smoke a cigarette. We hate the fucking woman. Is Aurora still there? Because of Aurora, I now have a sore throat. Which nobody's actually. Oh, stop! He's surely small. Gannon's channel. Let's have a look. A reminder of who this is about. Aurora says Gannon's channel only has one video recorded by Gannon, and a friend and his family decided to leave it up because he wanted to be a YouTuber. There you have it, guys. Get over there, subscribe, and like Gabby Petito, maybe other YouTubers can put in the cause and help Gannon become a YouTuber. Oh. Oh. Well, let's what's happened there, Pauline? Seriously, I know what's wrong with you tonight. Hopefully, the next jury get it right. Yes. So my argument, not my argument. Sorry. Let's just hope that none of them are related to the fucking district attorney. Oh. No idea what he's on about. I was glued to her trial. She's guilty and she'll be guilty. Subscribe to Trial Junkies, yeah? Yeah, but you know, like, Peacock, the thing is, when you've got, like, the rest of your life in prison, this is like the only, getting out the cell you're going to get, really. Because she actually gets off on tormenting Gannon's mother, the sperm donor, new wife, and her own daughter. Fuck her. Well, yeah, I'd rather not. But yeah, that's spot on. No, you're fine. You're fine. Oh, well, you ain't wrong. Why are you saying all the way from Quam 2K? God said we have to love one another. He never said we had to like anyone. Okay, sure, it's more. Trial Drunkies, you're welcome. I need a ciggy. Susie, yes, she'll be sentenced over again. That's the only bit that's going to be enjoyable, the sentencing. That's it. Unfortunately, though, this is a chance for Letecia to get out and play because that's basically what happens when they get retrials and when they're at trial, actually. It's a case of that. If you're just tuning in, you've just missed it all. Go back to the beginning. I read the document. Shorty Small says she looks evil. Jinx says Gibbo and laughing faces. I guess you think that's funny, do you, Jinx? I refuse. Okay. He had chances to listen and protect his son, but chose a piece of ass instead of sweet blessing. God gifted him. Fuck him too. Oh, okay. I'm not drinking. It's an energy drink. Let me put my cigarette down. Okay, so it's just an energy drink. Oh, I've got to turn the camera off because I'm smoking. Okay. It also gives her a chance to say all kinds of new lies, which I hate. Yeah, she is a piece of work. She is. Yeah, she had too much time to come up with new bullshit. Yeah, I mean, her story changed more than fucking yeah. So, to those of you that are going to follow the next trial, good luck. Anything else comes out between now and the trial, I'll get it out for you. Yeah, she's told enough stories already. Well, I think they can only use. Yes, I know you will, Susie. You watch all the trials. I don't drink, but not tonight. I'm raging too hard about teabag for that. Seriously, I don't booze after seeing this today. Her voice is so annoying. I can't remember it. I remember watching all the evidence. No, I'm not going to stream it, but we'll find a channel that is, and I'll share the hell out of them. Yada yada yada. Yada yada yada. Okay, we read out earlier who got the new memberships. I'd like to thank Jinx again for the 5 gifted memberships. 4 people. If you got a gifted membership, go over to the membership area. You can see me having lunch at my brother's work. We have members only lives. We'll probably have one this weekend. Um, it's Easter, guys. Tomorrow is Good Friday. So hopefully we'll have a live. I'm not sure yet. The topic will be Good Friday because it's Good Friday. Maybe we can find some funny cases from Good Friday. Maybe we can look into Jesus's conviction. I don't know. Thank you to Shaboogies for telling me I'm not a piece of shit and the super chat. And Sloothy Sweetheart has been a member for a month now, so that's actually her second membership, and she's put the bacon jerky. Yeah, well, we all knew she would. Okay, so that is it. Yeah, smash the like, share, subscribe, help me grow so we can keep pushing these stories out. I've got a lot of families that I wished Merry Christmas to, Merry Christmas, Merry Easter to, that I'm going to go and respond to their messages. They're all family members that we've had on the channel. If you're new to the channel, go and check out the uh, what's it called? The interviews we did with the families because their stories are majorly important. Our first case that's moving forward from the families that we've had on is Jack's Grattan. The 20th of, and it's actually Grattan. I was talking to the mum about that. But the 20th of April is the next court date. She's going to send me the court date over. I will, because I can't stream it because it's Colorado. What I'll do is I'll share it on a community post, and you guys can click it at your own leisure. I'll put the time and all that. It'll be Colorado's time. So you'll have to work it out yourselves, and you'll be able to watch it if you want to watch it. Let's go down. I'm sub now that I know you're on YouTube. Signed up for notifications. Thank you for reading all that. You did amazing. Thank you. Uh, Shorty Small, one of these days you'll get one. And so, Karen, how have you not got a gifted membership? You've been here since I started a year ago, and you've never got one. Shorty Small, that'd be nice. There's got to be something with your settings. You're gonna have to check your Settings. Merry Christmas. All right. No, thank you, Troll Junkies, for all you do and your great lives. Okay, so I'm off. You're going to see a 30-second clip. Again, if you've just tuned in, go back to the beginning. We read the document. Okay, I'm off. Goodbye. Goodbye. See you later. Ta-ra.